So today's webinar is on employee relations and redundancies, and Shane will be breaking down what you need to consider if unfortunately you are looking in your planning for the months ahead at having to make some layoffs within your organization. And so I will, without further ado, I will hand over to Shane to update us on what the current status is in making redundancies, in employees being able to seek redundancies, and the best advice that we can offer.
It is quite a heavy topic. I'm going to quickly just share my screen so that you can see my slides. As I said, look, there's a lot of information to get through, but what we'll do is we'll try and fly through it as quick as we can. The approach we're trying to take is that, you know, we're going to make it as practical as possible for employers, and it is quite employer centric. I suppose, you know, it is one of the areas that we focus on, especially in Holmes Sexton. We only act for employers and employment law units. So we are looking at it from an employer point of view. And I suppose each area of the talk we're going to look at specifically in terms of key takeaways for employers. So hopefully it'll be reasonably practical, have some takeaways for you, but at any stage, if you have any questions, pop it into the Q&A box. And also, you know, don't hesitate to contact me. My contact details will be at the very end of the slides, and you can get them from Quiva or contact the office directly and we can have a chat. So look, it's not a subject, as Dee said, it's not a subject matter that we generally, you know, like covering, but you know, it's a fact of business, and it's a reality, especially where we are at the moment. So so you see there just a quick background of the firm. So we've offices in Limerick, Dublin, Cork, and London. Full range of practice areas covered for corporates. So the unit that I'm responsible for, the employment law unit, we act exclusively for employers. We've got a wide range of clients, from startups to listed companies, and then it's split into two areas of work. We've advisory work and we've litigation. So your advisory is your advising on contracts of employment and HR policies, employee handbooks, pay-related issues. Then you have the litigation side, which is your WRC claims, and then which may end up in the labour court. But we act on, you know, we do both pieces of work for our clients. And then my unit is kind of part of the broader corporate and commercial group. So, you know, we handle corporate transactions, M&As and investments, intellectual property, commercial contracts, and all that kind of good stuff. So just to give you a bit of background on Holmes, I'm sure loads of you are familiar with us already, and I saw some of our clients are actually on the invite list, which is great. Right, so the aim of this webinar is actually to inform employers on the redundancy procedure, right, and provide some takeaways for you guys to implement on a practical level. The agenda then is to look at the legal framework allowing for redundancies. So what's the legal backdrop? You know, we'll talk then about the redundancy procedure, and the real importance here is the implementation of fair procedures. We'll talk about what they are and how to address that or tick that box. And then finally, then we'll look at the calculation of redundancy payments. So look, that's mostly a matter for the employee themselves, but obviously for you to discharge your obligation to the employee, you have to pay them their statutory amount, and we'll touch on those points as we go on a bit later. So first, look, a redundancy is a form of dismissal. You have to remember that. And anyone who has greater than 12 months service has the protection of the Unfair Dismissals Act, right? So what that says is that all dismissals are deemed unfair unless an employer can show that it was fair. It was a fair reason to dismiss someone. Now, on the basis that a redundancy is a dismissal, that redundancy then must result wholly or mainly from one of the 5 scenarios set out in the Redundancy Payments Act. Now, the talk won't be as technical as this. I just need to, going forward, but I just need to set the kind of background here for this, I suppose, which is really relevant going forward. So those 5 scenarios then, just I suppose to paraphrase quickly what the Act says, it's where there's a ceasing of a business unit, where the employer ceases or intends to cease to carry on business for the purpose for which the employee was employed. Second, where the requirements of that business for an employee to carry out work of a particular kind ceases. Third, And this is the one that often employers will hang their hat on when they're trying to demonstrate that they have a legal reason to make someone redundant. It's where you require fewer employees to carry on the work that you were doing. You know, that's quite easy to actually demonstrate. Four, where an employer has decided that the work for which the employee has been employed should henceforth be done in a different manner, right? So that's maybe a technological change or the purchase of a new piece of equipment. Turns out that you need less employees to do the work. That is a legitimate reason for a redundancy to be carried out. And fifth, then, it's a redistribution of tasks to another employee. Let's say that you're part of a wider group of companies and there's a reorganization that goes on. There might be a business unit that flips into another entity within the group, or even an internal reorg for a standalone entity. There's a particular employee who's then no longer needed, or that employee is also does a similar role to someone else. But how do you pick between them? You pick on the basis that that other person provides a far more broader background of qualifications and skills and can be used in other areas of the business. We'll get into this in a bit more detail in the fair procedures section, but that is the fifth reason why you can, I suppose, make someone redundant. Now, the reality is, and this is the key takeaway for employers, that it's not difficult to actually demonstrate that you have a genuine reason for the redundancy. So if you have one of those 5 scenarios, it's not difficult to demonstrate that. You can see there on point number 3, requirement for fewer employees. As long as you can make the case that you have the need for fewer employees, for example, the loss of a contract, or look, we're just going to do things in a different way, then you can see that it is quite easy to meet that test for having a genuine redundancy scenario. Certainly in today's economy, this is the relevance of the talk today and the timing of it. In today's economy, it shouldn't be difficult really to make that argument. Right, so when we know that we have a genuine reason for the redundancy, we have to demonstrate that the ingredients are there for that genuine reason. So we've practically determined that the reason is there, but in order for us to be protected fully as an employer, what 2 characteristics have to run through the scenario to make it legally, bulletproof? Number 1 is impersonality. Now, what that means is that it must be the role that is made redundant, not the person. So if I have 15 operatives on my factory floor, and I work out that I need 3 less because of a change in the way we're doing work or a loss of a customer, how do I determine who should be made redundant? And we'll get on to the selection process in a bit later, but what has to happen is it has to be impersonal, right? So you have to have decided that the redundancy is for the role only, not for the person. So I can't say, look, I want to get rid of John over there. He's not cutting the mustard. He's not meeting the level required. That's not really what a redundancy is meant to say. What a redundancy is meant to be demonstrating is that the role is no longer required. It's actually impersonal. It has nothing to do with John himself. The second characteristic is change, and you'll see in all of those 5 scenarios that it has to be based on an element of change. So you will have to demonstrate documentarily or otherwise that there has been a change to your the way that you're doing your work or your workplace. Now, I suppose that is there. In fairness, there the 2 key takeaways. It's quite simple on that front, the 2 necessary ingredients. But as long as you have one of the 5 scenarios, it should really flow that your ability to demonstrate change is there. Then the really key takeaway is it has to be redundancy of the role, not the person. Next then, and this is, look, a really, really kind of common theme at the moment, layoff in short time that lead to a redundancy. So first things first, look, what are layoff in short time? Layoff is obviously where someone is temporarily told not to report for work and they're actually temporarily unemployed. Now, it's temporarily unemployed because the relationship is not broken between the employer and the employee. They just do not report for work. Now, with short time, then short time its technical definition is that you would have 50% of your time requirement in work. So you're asked to do 50% of the hours, and then you're paid 50% or 50% or less of your pay. Sorry, it's 50% or less of your hours, of course. So is layoff without pay possible? There's been a lot of talk about this recently. Most employees and employers would assume that when you're laid off, you're just not paid. But in actual fact, your contract of employment has to say that there's a right there for you, for the employee not to be paid when laid off. That is a key point. We've seen a couple of clients fall foul of it in the last couple of months, and something to have a look at if you're looking at your contracts of employment after this talk. So typically, how do layoff and short time lead to a redundancy? Well, what the Redundancy Payments Act says is that if you have been laid off for 4 or more consecutive weeks, when I say you, I mean an employee, or for 6 weeks over a 13-week period, that you as an employee are entitled to go to your employer and ask them to be made redundant. Now, the employer then has time to actually, propose that there won't be a redundancy, and you can bring that employee back into the workplace framework and then give them back their job, right? But so it actually is, after a certain period of time, it's to give the power back to the employee so that they're not indefinitely laid off and in this kind of limbo. Am I employed? Am I not? The relationship is temporarily broken, but am I still an employee? So really, that procedure is there to protect employees. Currently, and for the period of what they call the emergency period, Heather Humphreys, put a suspension on that right. So employees can't currently actually claim redundancy while they're laid off, right? It's down to the employer. And the worry there was that there would be an avalanche of redundancy. So after 4 weeks of the initial phase of lockdown, if someone's laid off, were we going to see loads of applications for redundancy and the cost that would bring to the employers? While it's currently suspended, it's actually only suspended until the 17th of September, which is today week. So we kind of wait to see what's going to happen with the government, whether they'll probably extend that period a bit longer. But what it's doing is it's delaying that avalanche of redundancies while people are on the pandemic payment. But then again, of course, with you probably would have heard yesterday if you were participating in the webinar, the wage subsidy scheme, has been restructured now where it's not as an attractive position for an employee to be, so they want to be back at work. Look, the key takeaway there is that if someone's on layoff for short time, currently they can't claim a redundancy from you, but that may change in the future. Now, will employees step out into the breach, into an uncertain kind of environment, remains to be seen, but it's one of those ones that's an evolving situation, as a lot of things under COVID, I suppose. So, this entitlement to redundancies and dismissals, it's not always the case that a redundancy payment will be made when someone is dismissed, right? That seems pretty obvious, but just to give you the I suppose, 4 key points in that regard. If someone's made redundant by you, they are entitled to a statutory redundancy payment. But as part of you making them redundant, you have to go through offers of alternative employment and other, I suppose, aspects of fair procedures. Again, we'll get onto that in a second. But if someone is dismissed by reason of their misconduct, if they're summarily dismissed because of, for example, consuming alcohol on the job, that is not an entitlement to redundancy. They've been dismissed by their misconduct. That is not a redundancy. They're not paid any redundancy for that. Second of all, if someone resigns, that is not a redundancy either. If you have resigned, an employee has taken that step themselves, there's no obligation on an employer to make payments to them other than maybe what they're due in terms of holiday pay and things like that. Third then is a refusal of alternative employment. We'll touch on this a bit later. What it means is where an employer comes along and says, look, we're going to make your role redundant, but what I have here is an alternative role, and it's a similar role test will be provided or will be applied. So is that alternative role actually a similar role, and is it a suitable alternative for this person instead of choosing redundancy? Sorry, they can't choose redundancy. So what it is, in fact, is that if the employee refuses that alternative role unreasonably, then they're pretty much, saying, I don't want to be paid a redundancy payment. They've no entitlement to a redundancy payment. So we'll touch on that a bit later, but that is the case that, it's possible for an employee by their conduct to actually disentitle themselves to redundancy. So key takeaway is, there's a mutual obligation on the employee to act reasonably, Where the employer is acting reasonably, the employee needs to do the same. Collective redundancy then, look, there's thresholds there. For anyone who has a workplace of, greater than 20 employees, you have to be conscious of the fact that there's collective redundancy procedures in place. The Act sets out particular, procedure around how a redundancy should happen. Where, for example, if you have 20 employees and you're going to make at least five redundant, you have to go and notify the Minister for the Department of Trade, and then enter into a 30-day consultation period with the group of employees, who will appoint an employee representative, or if it's in a unionised employment, typically the shop steward will act, or a union representative will act. So you see there the thresholds for number of employees: 50 to 100, at least 10. It kicks in, it triggers a collective redundancy situation. You must go to the notification with the Minister. You must start consulting on a formal basis. Now, the actual, I suppose, the approach doesn't really differ too much in terms of that fair procedures aspect. But, when you've got a collective redundancy situation, you have to follow the rules to a T. It's not flexible like, I suppose, the kind of maybe 1 or 2 person redundancy is in some ways. And you should make sure that you consult with your advisors around the collective redundancy. It's got a lot of pitfalls. So in terms of takeaways then, like if you have even close to making 5 redundancies, you have to consider the collective redundancy scenario. So the second section of the talk is about fair procedures. Now, look, it's a concept that many people will have heard of and be aware of, and I'm sure probably fallen foul of over the years. Where does it come from? Look, it's constitutional right to natural justice. Every single citizen of Ireland has the right to natural justice enshrined in the Constitution. What does it mean in terms of fair procedures? It means that you should be informed, consulted, there should be a decision that's done fairly, and then there should be an appeal that comes around as well. Without fair procedures, it's pretty much guaranteed that there will be an unfair dismissal. So don't forget that a redundancy is a dismissal of sorts. Okay, the Unfair Dismissals Act applies to any employee who's got greater than 12 months service. Without fair procedures, you're guaranteed to fall foul of an unfair dismissal claim in the WRC. So in a redundancy scenario, you must apply fair procedures, i.e. informing the person, consulting with them, allowing them a chance to challenge your decision, allowing them an appeal. Otherwise, you are likely to lose your case in WRC, and we've seen it happen many, many times. So this is probably the area that employers fall down most often. Look, the key takeaway is no matter what employment law issue is at stake or at hand in terms of a workplace, it is absolutely essential that you look at what are fair procedures in the circumstances. How can I deal with my employee fairly? Have I engaged with them in a meaningful level and sought their feedback? You can't go too far wrong if you've done that. So in terms then of fair procedures in regard to redundancy, which is obviously what we're talking about now, not generally, which was what the previous slide was talking about. The first step is to consider alternatives to redundancy. So we touched on this a bit earlier. If you've decided that a redundancy is required, you've looked at your overheads for your business, you've said we cannot survive for the next quarter, 2 quarters, the next year unless we reduce our overhead, and our staff is our biggest overhead, we have to make some redundancies. Before you can actually carry out a fair redundancy, you must have considered other alternatives to redundancy. So really it's the last step. So for example, have you an opportunity to redeploy someone into a different area that's really successful, a different business unit that's really successful? Could you put someone on short time or layoff for a period just to try and maybe balance the books for a while? Can you apply a pay reduction? Look, I mean, many workplaces apply pay reductions after COVID hit. So April and May was, we were inundated with queries around pay reductions. Are pay reductions legal was one of the questions. The answer is, unless it says in your contract that you can reduce someone's pay, often they're actually prima facie illegal. But I mean, if my employer comes to me and says, we're going to reduce your pay, and I refuse, and the alternative is redundancy, there's a good chance that as an employee, I'm going to accept the pay reduction. And the final one then, which is pretty topical, is the employee wage subsidy scheme and the pandemic unemployment payment. There's some commentators argued that actually redundancies are nearly impossible while the employee wage subsidy scheme is in place, where the wages are being supported by the government and the overhead has been covered by a grant in effect. You know, is it possible to make an argument to make someone redundant where their wages are being paid by a third party? It's a fair point to make. I disagree. I think that like redundancy can be around restructuring of a business, or it's looking into the future, or it's technological changes. You know, it can be for many reasons. So, but those 4 points are alternatives to redundancy. They must be considered before redundancy will be, you know, said to be fair. So in terms of takeaway, it has to be viewed as a final step, really. And of course, like, it is justified in some cases, but you must demonstrate that you've considered the alternatives. Hold your management meetings, hold your board meetings, keep minutes to those meetings, have those filed away in case that there is a time when you have to pull it out, and if the WRC come knocking. So then I suppose when we get into the actual fair procedures of a redundancy, you've determined that redundancies are the way you're going to go forward. So, you know, you've determined that the overheads are too high. You've determined that you need to make some changes in the workplace. You've determined that redeployment isn't suitable. I'm going to make some people redundant. The first thing to consider is how many redundancies are required. So if we go back to the example, we have 15 operatives on a factory floor. I need to get rid of 3 of those guys, unfortunately. How do I go about doing that? Well, the first thing to do is to establish a pool for selection. How do I select those particular employees for redundancy? The pool is established really by considering who is in similar employment. So don't forget that it's the role that is actually being made redundant, not John or Martin or Joe. It's actually the role. So I need 3 less operatives. Now, if I have an operative who works in a different part of the business or the company in a different business unit, is that person in similar employment? Yes, I suppose is the quick answer. There has to be, I suppose, consideration, a very broad view of what the potential pool of people can be. So if you're saying I need 1 less operative or 3 less operatives, why is the operative in a different side of the business any different to this guy if they can interchangeably do each other's job, if they're in similar employment? So you have to take as broad a view as possible when you're establishing the pool of people who could be selected for redundancy when you realize that you need 3 less roles. Now, the balance to be struck there in taking the broader view is that, of course, if you're bringing people into redundancy procedure when there are, I suppose, you know, some really key members of staff, that doesn't have a great effect on the culture of the workplace. And like, I mean, if someone's concerned about being made redundant, they're hardly going to be, you know, giving their all in terms of their, first of all, their ability to, their attitude towards work. And second of all, they might be looking over their shoulder thinking, I need to get a new job here. So, you know, it's not exactly a great place to be when you've got that, how big is my pool? You're trying to balance the risk of inviting people into that pool so that you're applying fair procedures, but not unnecessarily choosing people that, you know, probably won't be made redundant in the long run. So I suppose as a key takeaway, you know, it is that wide pool that needs to be considered. You know, you're open to challenge if you do not apply a broad enough view on the potential pool. So then selection criteria. Well, like, I suppose I've established my pool now. How do I actually go and select persons for redundancy, where it's up to now being all about the role? How do I actually pick which of the guys and girls are going to be made redundant, right? So this is a crucial area for the employer to focus on. It's probably where, you know, 65% of claims come from in the WRC. Why was I chosen over somebody else? This is, you know, unfair. I'm a fantastic employee and I've been doing my job for 20 years. So really what you have to do is justify why one employee was chosen over another. Now, the criteria you have to apply has to be, and we know this from the case law, has to be independent, objective, and justifiable. Again, it goes back to that impersonality aspect of redundancy. So, you know, it's a very tricky task, actually, in fact. And how do you pick one person over another? There's going to be natural, you know, guys who are better than others at their job. And that is a reason to, you know, keep someone, of course, but you need to then put that into a process and a procedure. Now, loads of people have heard about LIFO, last in, first out. It is in effect a bulletproof manner of selection criteria, but it doesn't provide for the flexibility you might need. And that is because where you have used a redundancy procedure, either now or previously, it has then become custom and practice for that procedure specifically be applied to redundancies in the future, whether it's this redundancy if you've used it in the past, or in future redundancies if you're using it now. So with LIFO, it means that I might have hired someone a year ago. They might be the best employee I've ever had, but because of LIFO, I have to get rid of them first, right? That is not a great place for an employer to be. In actual fact, what you really want is to use a selection matrix, right? So a selection matrix is, it sounds a bit complicated, but in actual fact, all it is, you know, you've got your spreadsheet. Across the top, you've got some topics or quantifiable kind of, I suppose, subjects that you're going to look at each employee, your pool of employees under. An example of those are qualifications, relevant experience, and the skill requirements of the role. And what you'll see there is that they're objective criteria. So like if someone is more qualified than the other, that's an easy way to, you know, I suppose, see where they are against each other. It's not saying, well, I don't like John, I prefer Joe. It's actually saying, well, John is just less qualified than Joe, so we're going to pick Joe to keep. So when you can demonstrate that you've used a selection matrix and use it in a fair manner with objective criteria, then, you know, again, it's a very flexible approach that doesn't have that LIFO you must apply on the next redundancy if there is one. You've got a selection matrix process. You can use the selection matrix the next time, and you can even change around the actual subject headings of the selection matrix depending on the type of role that you're making redundant at this stage. So, you know, really in terms of the takeaway, flexibility is key. If you have LIFO already applied, you really must apply it again unless you have a very, very good legitimate reason not to apply it. And, you know, we can talk to people about that in detail about how you make an argument that LIFO shouldn't apply on this occasion. So giving notice of redundancy then, like, I suppose, as with any dismissal, you know, you have to provide their contractual notice. We've seen some crazy contracts in the past where someone has something like, you know, 12 months notice. Like that obviously is so hard to manage. But, you know, contractual notice still applies in a redundancy scenario. Now, obviously, it can be paid up in lieu. So, you know, for example, on garden leave or whatever, if you've got those rights in your contract, but you do need that contractual right to pay someone up in lieu. But like typically we'll say under the minimum notice statute, you know, if you have 4 weeks notice in your contract, then, you know, the employee will often say, well, look, just pay me up in lieu. I'm happy to go now. I've been made redundant. I don't want to stick around here any longer. It's you know, I'm sick of this place. I need to move on. So, like, people will always nearly come to you and say, yeah, I'm willing to accept payment in lieu. But you have to remember, actually, that in the Redundancy Payments Act, it applies for a 2-week notice period that cannot be paid up in lieu. So if the employee actually decides to stay, they can stay for, at least 2 weeks. But if the employer then decides to pay them off after that point, which is always advisable so that you don't have someone who's about to leave the company and is possibly there just, you know, swinging the lead or else just, you know, being disruptive, which happens all the time, you then choose to pay them up, but they can choose to stay for those 2 weeks. And in that 2-week period, you have to facilitate them in finding new employment. So if they say, well, I have an interview, by the way, in Belfast tomorrow, I need 6 hours off. That is what the law says. You have to facilitate them in finding the new employment. Now, it has to be reasonable. If they say I have an interview in New York and I need 2 weeks off, that's a bit different. So it's reasonableness, again, comes into it. That's, again, an aspect of fair procedures. In terms of, I suppose, takeaways, if you are planning on a redundancy and you have an idea of what the pool is like, get the contracts of employment out, check the contractual notice, check what the notice period is going to be, what your payoff is going to be like here, check in terms of how quickly can I get this done. It all factors into the practical reality of affecting a redundancy. So the logistics of an employee exit then, look, when an employee is leaving a company, it's always advisable that they sign a severance agreement. If they've been dismissed by misconduct, it's probably one of the only circumstances where you don't have them sign a severance agreement, because there's no reason for them to do it. There's no motivation for them to do that. They're just going to walk because they've been told to go. And generally, there's no comeback because they've been sacked for misconduct, so long as it's a legitimate reason for dismissal. Now, so the termination date for calculation of the statutory redundancy payment is actually the expiry of the notice period, right? And that is, again, check your contractual notice, see what date the person is actually going to be terminated on. If you've given them notice now and it's 4 weeks' time, their termination date is 4 weeks' time. In terms of severance agreement, then, it's absolutely key that you get a severance agreement in place with someone while they're leaving and being made redundant, especially. In the severance agreement, what it'll say is it'll waive all the claims that they might have against the company, where it says set out relevant statutes there. What I mean is, you actually have to list all the employment law statutes that the employee is waiving claims under, and that came from case back a decade ago now at this stage, but that basically the statutes must be set out in the agreement. It's also a way for you to get property back, which is often a problem, in terms of, well, I'm being made redundant, I'm keeping my laptop, I don't care, get it back off me. But, these are things that contractually then the person will be bound to return the property to you, and you have a legal right to enforce that against them. The one key aspect which is really troublesome for employers is, for a severance agreement to be enforceable, the employee needs to have taken independent legal advice, right? So that means they go to their own solicitor, and their own solicitor signs off on the agreement being effectively okay to sign for that employee. Now, the problem there is that you might have agreed a really cozy package with an employee in terms of, like, I'm going to give you a week extra on top of your statutory payment. The solicitor comes along and says, sure, that's nonsense. You deserve at least 12 weeks there. The employee then starts getting ideas about, well, I'm actually not going to sign a severance agreement until you give me my negotiated ex gratia payment, or what I want. And that is, one of the risks for bringing another lawyer into the mix. I suppose, but the problem is that if you go to try and enforce a settlement agreement without independent legal advice, it's the courts have said it's not possible. You can't pull the wool over your employees' eyes because of the position that you'd be in, possibly having advice guiding you through the situation. They should be entitled to that too. That is a key aspect of the fair procedure. So, like, in terms of key takeaways, like, it's not actually a legal obligation to have someone sign a severance agreement, so they can refuse to sign it, okay? But, like, without it, you are in, you're going to be concerned that for 6 months, which is the length of time someone has to make a claim in a WRC, this person is going to come back and say they were unfairly dismissed. Look, it's a fact of business life that employees have that right to make claims if they wish. You can't account for someone making a claim, but at least if you have the severance agreement, you've got them to waive their claims. They're unlikely to try and push that through. The third, I suppose, theme then of the talk is around redundancy payments themselves. You'll all be well aware the statutory redundancy payment is a legal entitlement for an employee where they've been made redundant. So the employee requires 2 years service to qualify for the calculation of a statutory payment, and it's calculated as follows, right? So for every year of service, they get 2 weeks of their weekly pay when they're being terminated, plus 1 additional week. So that's just 1 week, not 1 week for every 2 weeks, just 1 week at the end on top of those calculations of the 2 weeks. Now, luckily, it is capped at €600 per week. So if you're trying to make an executive redundant, those numbers could have been enormous for some companies, but it's capped at €600 per week. So generally, it's a kind of quite achievable amount for a company to meet. Now, if the employer can't pay, there's actually a social insurance fund that comes in to meet the employee's obligations. So the employee won't be left short, but the employer still has a legal obligation to pay statutory redundancy. The place to go to try and work out what a statutory redundancy payment should amount to is the Department of Social Protection website. There's a very good calculator there. They'll give you a pro rata based on, you know, if someone has worked for 6.76 years, so they break down the year and they give you a pro rata over their 600 euro a week or less calculation, and that then gives you the number that you should agree with your employee to pay them the statutory amount. So key takeaway there is go to the website, find out what your exposure is going to be, and make those plans early so that you have an opportunity to to consider what the saving is here. Next then, I suppose, is your ex gratia payment. Look, no legal entitlement or obligation. These are payments that are, very, very commonly made, and actually there's a very good reason why they're made, and that is because if you want to sign a settlement agreement, you actually need to pay an amount to give, contractual validity to that contract. So the consideration for the purposes of the contract is the ex gratia amount, right? So now there is the question we get all the time is about, well, how much do I pay someone? What's the right amount to offer someone in an ex gratia situation? Like, there is no answer to that unless there's been custom and practice in your business of, well, we've paid 6 weeks per year of service previously. If you've done that in the past, you have to have a very, very good reason why you wouldn't do that again. The law will say that you should. That has been set as the custom and practice, and that's the ballpark you need to consider. Otherwise, in unionized employment, often the union will try and make an agreement about what kind of payout would be made to their union members. Also, you could check if there's an industry norm for calculation. Some like engineering, construction industries do have calculations that have gone before that you can use as an example to agree an ex gratia payment. I suppose the example here is the debit and sit-in is going on at the moment. That is around actually how much ex gratia money are the employees going to get on top. You see the liquidator Kieran Wallace from KPMG said you pulled his offer the other day. So they were getting their 2 weeks plus 1 week statutory payment. The ex gratia amount then was, I think it was agreed at 2 weeks with their union mandate. Now, some of the employees said that, oh, this offer has been pulled, or sorry, we weren't willing to accept that. Next thing, Kieran Wallace says, grant, there's no offer on the table, offer's gone. Again, the evidence sit-in continues, and that's been going on for a long time now. So, these are the kind of issues that you try to avoid. It's reputational damage at the end of the day. A liquidator cares less, but if you had a trading business like that and you someone picketing the outside of it, not a great position to be in. So then the meaning of remuneration, like, how do I calculate what amount of their pay, or what is I suppose taken into account when you're deeming what to be calculated? So really, it's the basic salary, it's overtime, it's bonus and commission. And you might say, well, how do I calculate what their overtime, bonus, commission is if they haven't had a great month or they've had an exceptional month in the last month? In actual fact, the key period is the 26 weeks up to 13 weeks before the redundancy. That is where you will identify what their overtime, bonus and commission was, and that's seen as a fair period for you to calculate what the total remuneration package is. Then you multiply it out by the weekly entitlement, the 2 weeks plus 1 week. But don't forget, it's often relevant because if it's capped at 600 euro, if you're dealing with an executive who's making bonus or commission, generally that 600 euro cap will have been met by their basic salary. So it's less of an issue. The key thing here really to take away is contact your accountant, contact your tax advisor early. We'll touch on that more in a second. But bring your advisors in. That's what you're paying them to do. You need to get these things right, because if they're done wrong, you're going to end up in a WRC and you've got a 10 grand legal bill to look after, right? So tax relief on redundancy payments then, not my area of expertise directly, but like I do see a lot of it because of dealing with these situations. So the statutory payment is actually fully tax-free for the employee, right? So no matter what they're paid statutorily, that is tax-free. The ex gratia amount on top, the first €10,160 is tax-free. Then after that, for every complete year of service, not pro rata, every complete year of service, you get €765 tax-free on top of that. Talk to your tax advisor, talk to the employee's tax advisor if they have one. It could be agreed the manner of the ex gratia payment. Often there can be an argument that someone say, well, look, throw some into my pension pot for tax reasons. If you want to agree that with your employee, you can. It's also a way to say that, look, I'm coming to the table here. I'm trying to make this as fair as possible for you. You know, I need you to sign a severance agreement on the other end. So in terms of key takeaway, talk to your tax advisor. I think it's pretty much as simple as that. So look, that's it. Look, I'm sorry about the mix up at the start. I hope I haven't kept people too long. I haven't even looked at my clock once. We're 4 minutes over. It's not too bad, I suppose. I'm going to just click out of the slides here because we can then have a look at the Q&A and see if there's anything in here. So plenty of anonymous attendees. So obviously at this time it makes sense to focus on financially driven redundancy decisions. What if you just want to make a change in how your business operates? Would you be scrutinized for ability to afford not going through with the redundancies? Look, if it's just a change, not financial reasons, that is one of the genuine reasons for a redundancy. So you will have a genuine reason to make someone redundant. But the second part of the question, would you be scrutinized for ability to afford not going through with the redundancies? So what I think you mean is that, you know, would you be scrutinized for if you can't pay them? I mean, look, if they can't, there's a statutory obligation to pay redundancy payments. But if you can't meet those payments, then there is a fund, which social insurance fund, that kicks in. So are we expected to pay for independent legal advice? Look, it is often the case that you would include as a kind of a sweetener, really. Look, I'll give you €500 for a solicitor to review that independent legal advice aspect or meet that aspect of the contract. It's not actually a requirement, but again, it is a sweetener, you know, to put into the agreement. The requirement is that they have it, reviewed by an independent person. So if an employer becomes aware that an employee currently on layoff is working for another employer, how does that affect their redundancy entitlements? But in actual fact, that is an issue. It's a disciplinary issue for that employee, because while they're on layoff, they're still an employee of you, right? So if you have found out that they're working for somebody else, that could potentially be a disciplinary issue if you have in your handbook or in your contracts that the person has to be you know, devoting their time while they're employed. Now, then again, you could meet that person in the middle by saying, look, I understand that you have to go and make a few quid. That's fine. I wouldn't be enforcing that against the employee unless you want to, you know, really upset them. But what I will say is that, you know, if you wanted to make a problem for someone, I suppose, you know, you could. But then again, if they're not delivering services to you at the time, again, it comes down to the contract and the wording of the contract, whether you're allowed to enforce that against them or not. What is the criteria for being deemed unable to pay statutory redundancy? So, well, I mean, it's just that if you can't meet it, I mean, like if you are technically insolvent in some ways and being kept alive by subsidies and grants, I mean, if your P&L says that you literally can't meet certain overheads, you know, the criteria will be down to you demonstrating that you literally cannot do it, that you have, you know, a massive overdraft and you're failing to get any more money from the bank. Or, like, don't forget, as a director of a company, you have an obligation to not trade recklessly. So, like, I mean, if you were paying out money for redundancies, it is seen, I doubt that it would be seen as reckless trading because you're trying to, you know, support the survival of the business. But reality is that, like, the likelihood is that you just go and ask them to claim off the government insurance fund. But again, it's down to paperwork. It's kind of case by case basis. We could have a look at that with you if you want. I think I better leave it there. There's some questions in the chat. What I might do is I'll come back to those individually. My email actually is on the back of the slides. Like, you know, we're a good bit over in time, so I'll just let you guys go. Listen, thanks very much to Limerick Chamber for everything they do in terms of running these webinars. Like, they're very, very helpful. This is the second one I've been involved in, and you know, they're free, obviously, so it's a great part of the membership. So thanks, Viva, thanks, Dee, and if anyone has any questions, just send me an email or give me a shout on the mobile. All the details are there.
Shane, thanks so much for your time today, and nicely recovered, might I say, from the technical difficulties we had at the start. And again, just to reiterate, if people have any further questions, please don't hesitate to either contact us through the Chamber or Shane directly, and we will be circulating the video of this event afterwards to registered attendees. Thank you for joining today. See you next time.